educated enough to be able to present or to propose a law, or maybe the subjects or the topics of the law were more were the kind that government had initiative.
Well, from the beginning, most bills were brought in by the government. This did not change in the later years. What I meant was that the expertise, the formal expertise by the parliament to adapt, discuss and change these bills decreased dramatically in the late 19th and especially in the early 20th century. And the example that I used was the December Constitution of 1867, the Austrian December Constitution, where the government only brought in a few bills very formally, and the House of Representatives took the initiative and created these laws, and that the House at that time did have the legal expertise to draw these bills and laws. And an initiative in this kind would have been very hard in the earlier 20th century. I do not think that the Houses of Parliament and the House of Representatives, the Austrian House of Representatives in 1907 and 1911, would have had this formal expertise within itself to write the legal texts. And this dramatically changed. It did not change in the House of Lords. The House of Lords, even though it was appointed, about 2/3 of its members were members for life, appointed by the emperor. The other third was hereditary members or members due to the as bishops of the Catholic and Orthodox churches. The House of Lords even increased its formal expertise. And this was due to the case that quite a number of retired ministers and university professors were appointed as members for life. So there is this theory that somehow the House of Lords functioned as a legal corrective to the House of Representatives. So what I did not mean was that in the actual process of lawmaking, the initiative was taken very often in the early years. That was only the case in at very special times, especially in the late 1860s and early 1870s, with the December Constitution, and then especially with the laws, with the religious laws and the laws on education, that is freeing or somehow restricting the power of the Catholic Church in legal matters. At that time, the Austrian Parliament, the Viennese Parliament, had in its rank and file the expertise to write the legal texts. And I do not think that this expertise, not that the others were stupid or did not understand what was going on, but they did not, in the majority, they did not have any longer the formal qualification to write legal texts. That was the point that I wanted to make.
Anything else? A comment?
Thank you both for very interesting lectures. I have one question for colleague Adlgasser. Can you tell us something about social and professional background and educational of Croatian parliamentary members in the Austrian parliament?
I can see a clear difference between these areas in the Austria, as I want to call it, that have that developed rather early these forms of modern political parties and areas that are, if I might call it, backwards in this kind of things. And the two predominantly Croatian areas or crown lands, Dalmatia and Istria, definitely belonged to the second type with a rather late development of mass parties, both on the left and the right. What this meant was that both in Croatia and Dalmatia, lawyers and other academically trained deputies were in numbers much higher, or in percentage much higher than, for example, in Lower Austria or in Bohemia. A special case in this thing is Dalmatia, that in 1907, after the introduction of universal male and equal suffrage, make that clear, universal male suffrage was introduced in Austria in 1897 for the first time. Universal and equal male suffrage was in 1907. This is a confusion that you read most of the times. Dalmatia was the one crown land that sent the highest percentage of Catholic priests into the House of Parliament. This had to do with this, in my eyes, with the party structure that the Croatian conservative party was very much dominated by the Catholic hierarchy, and the strong influence that the Catholic hierarchy had in the somewhat academic area of the Dalmatian civic society. So these two specialties I see for Istria and Dalmatia, that is throughout the whole period, a very high percentage of academically trained parliamentarians and a strong representation of Catholic priests in the House of Parliament. The one thing that you will not find in the Croatian, with a few, only very few exceptions, is that you hardly find great landowners, the kind of magnates that you have from Bohemia, from Galicia. This has to do with the totally different structure of land ownership, in especially Dalmatia, and the ones that were sent from Istria were usually ethnically Italians. This is the case in Istria. The Italian minority was overrepresented in the House of Representatives up to 1907 due to the election laws.
I have to Franz three short remarks. First, István Tisza deeply analyzed the election of 1907, and the results of the elections was a negative example against the universal suffrage in Hungary, because the niveau of the parliament will decreased because of universal suffrage. The second, in Hungary also is prepared a database of the Hungarian MPs. It contains about 4,000 persons now, and this research group led by József Papp in Eger, and of course founded by the Hungarian parliament, similar to the Austrian situation. And the third, it was interesting that the social data of the Austrian MPs was very similar to the Hungarian social background, of course before 1907, although the history of and development of the Austrian and Hungarian parliamentarism was totally different, but the social background of the political elite was very similar.
I'm not familiar, of course, with Tisa's analysis, but I might suggest that his results were some kind of a self-fulfilling prophecy. That's what he wanted to read out of the elections, of the results of 1907. Negative example, I would not say so. I don't think that the level decreased. It's just the expertise that was represented there changed. What you didn't have that much anymore was legal expertise that you developed through academic education and through your occupational occupation as a lawyer, as an attorney at law, as a judge, as a high civil servant. But different expertise was brought in, coming from different experiences. That is, the expertise that came in from trade unionists, the expertise coming in from functionaries in agricultural cooperations, in agricultural organizations, the expertise coming in from functionaries and employees in health insurance, coming in from pressure groups, coming in especially from NGOs. They were not called NGOs at that time, but that's what they were. That's the civil society, and the civil society changed. And NGOs were pretty much more, or different NGOs were represented in the Austrian House of Parliament, in the Austrian Parliament, in the early 20th century, and early on. Earlier on, it were mostly the traditional groups of the chambers of commerce, of the industrial organizations, industrial pressure groups, and towards the end it was especially agricultural interests, and that is farmers, small farmers, agricultural interests, and middle farmers, agricultural interests, and on the left, the organized interests of the workers, of the industrial workers, and also the organized interests of especially the Catholic Church, as it was organized in its own organizations. The one big group that never was represented in the Austrian parliament are agricultural workers. The family farmers and the great landowners were always represented, stronger at shifting. But the one group that basically did not have representation at all were agricultural workers. And of course women didn't have them. But this is a long-going story. But I would just say that the expertise changed. It did, in my eyes, not decrease. The parliament lost expertise in certain fields and acquired expertise in different fields. The problem why the Austrian parliament did not function over long periods of times was not this so-called downsizing or loss of niveau. These were different other problems there.
Thank you. Anyone else?
I have a question for colleague Cieger. Can you tell us something about the quality of parliamentary debates in the Hungarian parliament, and especially about the attitude to the Croatian parliamentary members? What was the situation in the Hungarian parliament about it?
Yes, I tried to analyze this question 4 years ago in the collective book with the Croatian colleagues. I think during the 5 decades, the Croatian member of the common parliament were a bio decoration. Bio decoration. They silent during the decades, 5 decades, but the turn of the century was a big crisis between the Croatian MPs and the governing opposition parties after 1906, because the coalition with Croatian colleagues, virtual coalition with Croatian colleagues diminished. The national because of national claims.
Even though the only language that was recorded in the Austrian parliament was German, it was of course allowed to talk in any of the acknowledged languages in the Austrian parliament. Only in 1917 a law was passed that also non-German speeches were recorded. What non-German speakers usually did was that they took the oath to the parliament in their native tongue, and also that they started their speeches in their native tongue, and that's also something that the Croatian parliamentarians did over and over again, and then switched to German. where it was a real problem was not in the plenum of the parliament, but in the committees, because the committees were run in German, and you had to have a very good command of German to be able to participate in the committees. And that's why most of the Croatian members of parliament, you could see that they were either trained in Austrian universities, either in Vienna or in Graz mostly, or that they had a pretty good command of German. Otherwise, it would have not been possible for them to participate in these areas of the parliament where it really is important, and that's not on the floor, where you're basically not making the laws, but you're talking to the public, which was much more important at that time than it is today, but in the committees. And that's why a command of German was so important for all parliamentarians if they really wanted to participate in the legal process, in the parliamentary process.
If there are no more questions, I have one more for colleague Cieger. Regarding these, the nature of these legal texts asserting the long tradition of parliamentarism in Hungary, I was wondering, did you track, for instance, this Timon Ákos? Does he refer to some earlier authors of similar texts, for instance, from the beginning of the 19th century? Because legal studies were usually incorporated with teaching history. Does he refer to some other texts of earlier date, say from the crossing of the 18th to 19th centuries? And do these, if he does, and if you have investigated, come upon similar texts, do they correspond in their attitude towards this long legal history and the long tradition which legitimate the current issues?
I'm not a medievalist, but if I know correctly, of course, the first legal text in the Hungarian history goes back Saint Stephen, the first king of the Arpad age, the decrees of the first kings. But it's not extraordinary. These laws was created in the 11th century, but it's not too old. This was a competition among the nations in the Central Europe. That's why the nationalists wanted to go back earlier centuries, of course. And the anonymous Gesta-Hungarian was adequate for these current aims. And of course, the Golden Bull was addicted in 1222. Was similar to the Magna Carta in England, and that was the ground, the common ground of this theory, the English-Hungarian parallel.
Thank you. And now, if our discussion has come to an end, I would like to thank our lecturers today for participating, sharing their research with us, and thank you for participating in the discussion. Have a nice day.